What does it involve to prepare for an arbitration hearing? 2 seconds and we jump into all the info. Hello everyone, my name is Maria Rubert, lawyer and arbitrator with a base in Dubai in the UAE for the past 15 years. Today I'm happy to be with all of you to share something that is not that common. But I hope it is of help to those arbitration lovers and those arbitration practitioners, especially junior practitioners, law students who are walking into the amazing field of arbitration. What I want to talk to you about today is what does it involve to prepare for a hearing, for an arbitration hearing. I'm talking about a hearing on the merits. So what steps are involved in preparing for the big day or the big days? Usually the hearings that we often have last for 2 to 3 days, and they cover opening statements by counsel, witness evidence, witness statements. So the witnesses that prepare their testimonies, they come and are able to address any questions that us as lawyers, or we are also able to ask questions to the witnesses presented by the other party, and of course the tribunal. This is key for the tribunal to ask all the questions that they will probably be needing to fine-tune and finalize their decision making and draft the final award. There's also expert evidence will need to be present. But preparing for a hearing is not only preparing for what you are going to say in that opening statement, usually also closing statements. Those are very interesting, but sometimes the parties do agree to file them via post-hearing submissions. But if not, you need to be very fast because things have been happening, especially if you have a one-day hearing. You will need to be very fast at the end to draw the main issues that need to be clarified, etc. Right? So when do we start preparing for the hearing? Usually, in my experience, we start preparing about a month in advance. And what happens a month or 5 to 6 weeks in advance? Usually the parties and the tribunal hold a pre-hearing conference. So you usually connect online and you agree on a number of matters that may not have been addressed before. The agenda, whether it's electronic hearing or you're gonna meet, it's gonna be a physical hearing, all that has to do with that big day or big days. Yes? So that usually happens 1 month in advance. What also is gonna have to take place in advance? In advance, you also are gonna have to prepare the bundles, and this is a big headache, but it's great. Why? Because if you know what you're gonna put in this bundle, and this is a small one, yes, I'll explain you why. But if you know what you're gonna put in this bundle, means that you know what you're gonna use in your opening statement and what is likely that you are going to be addressing with your witnesses. Yes? Me, at this very early stage of the preparation, at the beginning of the preparation, the easiest is just to put everything in. Why? Because you're gonna have to agree the bundle with the other party, right? But sometimes if you wanna put everything in, you're gonna have several of these, a number of these. And this is a headache. It is a headache because sometimes you need to jump from bundle A to bundle B, bundle 1, 2, 3, whatever you want to name them, and it's a little bit of an issue. So sometimes what we do, and also it is the claimants that must take the initiative in preparing. Usually you prepare the index of all the documents that you will eventually put in the bundle. I have removed all the details on both sides, so for confidentiality purposes, of course. But usually you prepare the index and then you share with the respondent, and or they share it with you. And then once you finalize, it is the claimant, the one that needs to print it and index it and put new page numbers, because usually you will have already, you will have all these documents already submitted in the arbitration. So you may be asking, so why do you want to rename them, re-index them, re-page them? Because at the hearing you cannot be jumping from the statement of claim exhibit C3 or a statement of defense exhibit C18, R18. Yes, usually the claimants put for exhibits C claimant and R respondent, and when it's for legal we will put CL or RL, and this is the way we name the exhibits throughout the document, the writing stages. Yes. But when it comes to the bundle, it's very difficult to be saying, statement of claim, exhibit this, exhibit that. So you can just refer to this and you say page 58 of the bundle. Yeah, so everyone can go to page 58 of the bundle as one of the parties is doing the opening statement or the closing or whatever it is. So it's easier to follow without losing anyone and without losing the flow of that statement. Yeah. So that's what we do. So we do the index, then we agree, and then we prepare these bundles. Sometimes it can be electronic bundles, but arbitrators, myself, when I act as arbitrator, I have a strong preference to have this in front of me because it's going to help me prepare for the hearing. It's also going to help me to follow very easy, and I will be able to concentrate on what the parties are saying. Yes, so usually the bundle you will want to submit usually 1 week in advance, and then also you are going to submit in advance your opening statement. So the arbitrators will need more or less where you're gonna go around. Usually arbitrators know because they have your pleadings, but it's good for preparation. And I was saying that this is a pain in the neck to have to prepare. Yeah, and of course you have executive assistants, you have junior profiles that can help, but believe me, I won't be able to stress enough how much I participate in this, in the preparation. Why? Because it's hearing preparation. By knowing the documents, I'm also re-studying all the documents. Keep in mind that many arbitration cases last for over a year. I would say an average from 1 to 2 years is the average. So it's been a long time since you prepared the statement of claim or statement of defense or the document production or the witness statements. So for the hearing, you really need to know everything. Everything needs to be in your head. It's like, as I say, as I share with my team, it's like that big exam that you have and you need to be fully prepared. So usually it takes 1 month. The first 2 weeks are easier while you prepare all of this, but the last 2 weeks in preparation, sometimes you cannot think, you cannot breathe, you cannot do pretty much anything. You have all the facts, all the legals in your mind, and you keep going in and out in preparation. So usually 1 week in advance you will file the bundle, and then usually it's 2-3 days in advance the opening statements that you intend to use, and then from that moment you really study the documents. Why? Because you can be asked any question. Sometimes you will need to be very fast if the other party is mentioning a point, so you will want to really be fast and jump from one idea to the other and ask questions on point. So this is what I usually do for hearing preparation. A lot of administration parts, printing and organizing, but for me, it helps me to get immersed in the case and prepare for the opening, the closing statements, and for the big days. I hope that this has been of help. I will be addressing other parts of the arbitration process, as I've been asked for a number of you. Thank you so much for your loyalty to my channel. If you have learned a little bit, please do like my video. Please do subscribe so you can get to new information as soon as it is out. Also, you can follow me on social media, where I usually announce the videos that are being posted. Thank you very much for your time, and any general questions, please shoot them out. I usually cover legal parts of the legal world of living in the UAE, especially in Dubai, and also occasionally about my true passion, which is arbitration. Thank you very much.